Help me grow, fast or slow, as long as I know you're digging for gold. Help me learn, soft or stern, as long as I know you're digging for gold. Life's a movie, the ultimate trip. You should have been told you'd be digging for gold. Welcome, my friends, to another episode 32, by the way, of Digging for Gold. I'm your host, Dan Goldberg, as you know, and I want you all, if you would, be so kind as to subscribe on YouTube, on Spotify, on TikTok, on Instagram, on Good Pods, all the different platforms that carry our show. Just go to dangoldberg.com. At the bottom are all the icons. Just click on them and subscribe or follow. Today, I have a lifelong friend who is going to help you as you go through life planning your finances. He is one of the two founding partners, if you're from the Philadelphia area, of My Philly Lawyer. He also has a radio show on Praise Radio, 100.6 in the Philadelphia area as well. And maybe you can get it on other channels,
probably
on social media. And his name is Saul Langsam. And Saul and I have been friends for many, 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 many years. Decades. Multiple decades. Saul, welcome. It's
Why,
a
thank
pleasure
you,
to have
Dan.
you.
Thank you for having me.
Tell us about estate planning and what it entails. And what are the pitfalls and what are the positives?
Well, estate planning is coming into its own because people have been accumulating a lot more wealth, and with that accumulation, people start thinking about protecting that wealth. They start thinking about minimizing taxes, such as Pennsylvania inheritance taxes or federal estate taxes. And so there's been a dramatic change in the mindset of the public when it comes to estate planning. Decades ago, when our grandparents were breadwinners, everybody struggled to keep a mortgage over their head. If they were fortunate enough to make a car payment, there was really no accumulation of wealth. And with the passage of time, as the concept of education gets pushed to each of the upcoming generations, the ability to earn money improved dramatically, where people are at the point where they consciously have to give some serious thought to protecting those assets that they spend a lifetime accumulating. And so with the onset of COVID, that was the trigger. COVID was the trigger because with COVID, people had an opportunity to do some serious soul searching to better understand this particular area of estate planning. And in its very basic form, estate planning, when it came to the oldest of generations, was a simple will. If you could convince them to do a will, because the older generations clearly were not trusting. Our grandparents or our great-grandparents' generations, they were not trusting. They wouldn't even tell you where they kept a savings account, for fear that somebody might rob the bank and their money would be gone. That was the mentality.
You're right.
But with the passage of time, people have become much more sophisticated and much more open, so that if you have the good fortune of accumulating wealth, and it's not a dollars and cents issue, is what you perceive to be the value of your estate because of all your hard work, you have to sit down and have these discussions with those family members that you intend to benefit from your hard work.
So how do you figure things out for the benefit of people? What does it entail?
Well, it's a detailed exercise. When people reach out, when clients reach out to us, in many instances, they've already thought this through, and the majority of the people ask for information about wills. And a basic will simply identifies who your beneficiaries are going to be. And a basic will set forth what your named beneficiaries are going to receive in the way of an inheritance. And the will also needs to name an executor, or if it's a female, an executrix. And we always recommend that you name an alternate, because there's no guarantee that your first choice is available, willing, or able to serve. So that's an absolute necessity. Okay, now why is that? Because if you pass away and you own property and you do not have a will, Pennsylvania has an intestate statute. And the intestate statute is going to tell your estate who is going to inherit based upon the relationship of family members to the decedent. And in many, many instances, you will not be very happy. But since you're going to be resting comfortably 6 feet under, you're not going to be around to object. And so you must, and this is why COVID came into the picture, it triggered a clear need to put thoughts in writing. And give you 2 life examples that we talk about. We talk about all the time. So I had an elderly client who I did a will for, and the client had 4 children. He had 2 daughters, and he had 2 sons. Sadly, he had no relationship with the sons at all, and one or both may have been incarcerated, but he was extremely close with his daughters. So he comes to me and says, Saul, I want a will. I want to make sure that everything I own goes to my 2 girls. I have no relationship with my sons, and therefore there's no reason for me to leave them anything. And we did. We prepared that document. So the time came when the father passed away, and the two sisters came to me and said, Saul, you did Dad's will. Will you do the legal work to handle the administration of the estate? And I said, not a problem. And the will had the language left everything equally to the 2 girls. Now, we finished the administration of the estate, and we're sitting in my conference room, and I'm talking to the 2 sisters. Now, sitting directly across from me is sister number 1, who's a single woman, not married, no children. Sitting next to her is her sister, who is married with a 6-year-old. Okay? So I said, we have one final bit of business. And I looked at this single sister and I said, you need a will. And she looks at me and says, Saul, why do I need a will? I'm not married. I have no kids. And I said, your father just gave everybody a lesson and it passed over your head. So I said, let me ask you a question. If you have no will and you close your eyes tomorrow, who's going to inherit your property? And she looked at me and I said, do you want me to tell you who's going to inherit your property? Please. Your sister sitting right next to you, she's going to inherit 1/3 of your property. What do you mean 1/3 of my property? You have 2 brothers, don't you? Each of your brothers is going to inherit 1/3 of your property. The law doesn't have red blood in its veins. The law has ice water. And under our statute, if you pass and you're survived by a spouse, you have somebody to inherit. If you're survived by children, you have somebody to inherit. If you're survived by a mother or father, they will inherit. But in your situation, unmarried sister with no child, you're survived by 3 siblings. And under our statute, each of those siblings will share equally in your estate.
Wow.
And she stood up and said, really? Well, she actually stood up and screamed and said, how quickly can you do a will?
Wow.
So I said, as quickly as you want. I mean, that woman ended up naming her sister as the beneficiary of her estate. But since then, she could have gotten married and the will could have changed. So then I get involved in this ugly litigation between brother and sister. Mother dies. It wasn't a big estate, but they could agree on nothing. Sister was single. Brother was single. This ugly case litigated for a year. Ugly case litigated for a year before it got resolved. And, of course, they weren't any happier with each other at the time of the resolution. So we're going back to my office, and I happen to represent the brother. And I had the same conversation. By the way, before you walk out of my office, I said, you don't have a will. And he looks at me and said, so? I said, what do you think's going to happen to everything you have accumulated and just fought for the last year if you die tomorrow? Your only heir is your sister, the woman you just fought in court with for the last 12 months. She's going to dance on your grave because she's going to inherit everything you own.
Wow.
And I'm telling these stories to the radio listening audience. They said, is this really possible? I said, I'm not pulling anybody's leg. COVID then triggered this, hey, I better get my will done. And having a will prepared is not the result of accumulation of wealth. The underlying theme between wills, trusts, powers of attorney for elderly parents, healthcare directives is control. Control. And the younger generations are learning it rather quickly. The demand that I get from millennials and Gen Xers for healthcare directives. Now, what's a healthcare directive? A healthcare directive is a writing, it's a legal writing. It's written instructions to their medical providers. What does medical providers can and cannot do if, God forbid, they succumb to some type of incurable disease? That's control. Adult children are dragging their parents into our office, getting powers of attorney, because as long as a mother or father is competent and reasonably in control, legally they can ask for a legal document to be created, review it, sign it, have it notarized and witness. And that's going to be a lifesaver for that adult child, because without that power of attorney, they will not have the authority to speak on behalf of a parent. So I get numerous phone calls from either adult daughters or adult sons. Somebody called the other day, I'm in my mother's bank, I have to take care of something for her, time is running out, and they're asking me for a copy of the POA, power of attorney. I said, yeah, under all of the privacy acts, they're not allowed to reveal that information, even if they know that you're the flesh and blood. And so to avoid that problem, the power of attorney, which allows the child to speak for the parent, is an extension of the parent controlling their wishes. Because the good thing about the power of attorney is, with the POA, the child can be consulted by the parent and they can work together to make a decision. But should there come a time when the parent is not capable of making a decision on their own, the power of attorney allows that child to speak for the parent.
What about the spouse?
If there is a spouse, if there is a spouse, again, that's an interesting thing. I mean, in most instances, if God forbid one spouse is not well, they will give a power of attorney to their spouse. But you run into issues with blended families. It's one of the hardest issues that I deal with is blended families, because blended families don't always blend together. And many times the two adults have an understanding. What I brought into this marriage goes to my children. What you brought into this marriage goes to your children. We'll live together as husband and wife, but God forbid there's some type of calamity or serious illness. Who's getting the POA? Is it the oldest child of the mother or the oldest child of the father? They got to sort all these things out.
Wow.
I mean, they have to sort it out. Now, there's one pet peeve I have which creates turmoil for everybody. And that pet peeve is, and everybody's heard it on social media, the worst thing you can do is own anything in your name. The worst thing you can do is have a bank account in your name. The worst thing you can do is own property. Why? Because then you have to go to probate. Well, obviously 99% of the population has no clue what probate is. There is an inheritance tax, or they'll say, I don't want my estate to pay inheritance tax. Well, in Pennsylvania, if there's an inheritance from a parent to a child, it's 4.5%. It's not really a big deal. The real concern is with high net worth people. And you take a look at the IRS definition of a high net worth person, and that's a person whose wealth begins at $12.9 million. Okay, they fall into the 1%. If you're only the 10 million category, you're only at the 2%. But the high net worth people do make a genuine effort to own nothing in their name. They're not concerned about the Pennsylvania inheritance tax, which is 4.5%. If children are going to inherit, their concern is a federal estate tax, which will take a 51% bite out of your estate. So if you own it and you don't protect it, Uncle Sam gets a piece of it. So they like to dump things, but most people don't understand estates, and I don't understand trusts with estates. And I get called all the time, well, why shouldn't I have a trust? I said, you can have a trust if you want. A simple will may cost you $400. A trust is going to cost you $4,000. Why so much money? I said, because it's a totally different animal. I said, number one. Number two, if you create an irrevocable trust, that means you no longer have a voice. The trust speaks for you. And you name trustees and you make sure that the distribution of assets within the trust is what you approve of. That trust has to apply for an EIN number because that trust is a taxpayer. And they say, oh, I didn't know that. I don't want a trust that I have to file an income tax return for every year. That's what it is. And then the other pet peeve is, I'm told I should not own my home. It's got to go into a trust. I said, it's an interesting concept, and I don't have a problem with it. I said, 2 questions. Do you have a mortgage? Yeah, I have a mortgage. I said, if you have a mortgage, there's very specific language in the mortgage document that says you cannot transfer any equity in this property to anybody else without the written permission of the mortgage company. So if you're going to transfer your home into a trust, you are in essence taking your name off the deed, and you are creating a new deed, and in the new deed will be the Jones Family Trust. You're not the owner anymore, and you have now breached the terms of the mortgage. And so unless you get the permission of the mortgage company, you have a problem. Whoa. And the public does not understand these things, and they just argue constantly with me. And I said, you do whatever you're comfortable with. It's perfectly okay. You want to do it, go for it. So, but today, I'm more so than ever because people work so hard to accumulate assets. A lot of thought goes into doing wills. Wills can be simple and wills can be very complicated. I've got clients who are in real estate and must own 50 pieces of property, and they got each property earmarked to a family member or a child, and what should be a 4 or 5 page will becomes a 15-page will. But that's okay, as long as your thoughts are reduced to writing and it speaks on your behalf. Now, the other point, which is very important, is that the will document is not written in stone. So when we prepare a document for somebody, they walk out of our office with it, that document is subject to change anytime their heart desires. And we get calls every week for will changes. Something as simple as, my brother is named as my executor and he's moving to California. My sister still lives in Philadelphia. I want her to be the executor. That's a will change.
Sure.
Yeah. And I have some elderly clients, sadly with no family and a lot of money, whose will consists of numerous charities. And I'll get calls from them saying, Saul, I left $2,500 to the Salvation Army. I think I want to increase it to $3,000. That's a will change. Okay,
right,
it happens all the time, and so there's many positive reasons for will changes as there are sad reasons for will changes.
It's amazing. Or somebody gets married.
Somebody gets married, and then you reevaluate your relationship with that person and
right.
what you think their entitlement is. But one thing. In Pennsylvania, because the law in Pennsylvania protects the institution of marriage, the one person you cannot disavow or exclude in your will is a spouse.
Wow.
If you have a girlfriend on the side and you're married 50 years and you say, you know what, I'm giving my girlfriend everything, my wife will never find out, and when I'm going, that will can be successfully challenged, and that spouse will be entitled at least to a 30% interest in the value of the estate.
Did you ever run into that?
I have run into that. One of my, 1,000 stories. So one of the first estates I ever handled, being a young attorney, not really green, I was asked by a family member on my mother's side, not my side, my mother's side, if I would get involved in this particular estate. And what happened was, it was an elderly couple with 4 adult children, 4 very successful adult children. And the wife and the husband were stock pickers. They each had their own stock portfolio. I'm going back 40 years, and the wife's portfolio then was worth about $750,000, and the husband's was worth about $2 million. It was a lot of money. So the wife felt, we did a will, and the wife said, my husband doesn't need any money. I'm giving the money to our 4 adult children. Nothing wrong with that. Wife dies first. I'm asked to be the attorney for the estate. Husband hires a lawyer to challenge the wife's will.
Oh, my God.
A will that leaves everything equally to the 4 successful adult children. So that was, and that went before Judge Klein, who was in the orphans court at the time. Everybody was scared out of their wits when they walked into Judge Klein's courtroom. I was wet behind the ears, so I didn't know enough to be scared of him. But anyway, he heard this case. And the short end of the story is that within 12 months of the wife dying, the husband died. And in his will, he left everything to his 4 children.
Wow.
No lie. No lie.
Why did he challenge his wife?
Not only did he challenge the wife's will, but legal fee was rather meager at the time because I didn't know better. And
Right.
whatever my fee was, I probably consulted with some people, and I had a very modest fee. And we happened to be in Judge Klein's courtroom, he had a reputation for being bold. And the father's lawyer objected to my fee, and the judge was taken back. And this was in the heat of verbal battle. I mean, the judge already had enough with this nonsense, challenging the will when everybody knew it's going to the kids. And Judge Klein looks at me, and I'm out of my element here. I'm that nervous. And they're challenging my fee. And Judge Klein looks at me in open court and said, if Mr. Langsam would make a motion before me right now asking that the court approve his fee being doubled, I would grant it. And I think I'm hearing, and I'm stumbling, Judge, I'd like to make a motion, and the words come out of my mouth, Mr. Langsam, your fee will be doubled. And he turns around to the attorney for the husband and says, do you have any objections?
I love it.
Oh, this real life drama.
Wow.
Real life drama.
You gotta love that.
Yeah, but for everybody listening, you cannot underestimate how important it is to get your wills done. You don't have to be married. You don't have children. You're young single people are starting careers. They're accumulating assets. You better have a will. You better have a will and identify who you want to be the beneficiary.
Yeah. Even if you don't have assets now.
Even if you don't, you might win the lottery tomorrow.
That's correct.
Yeah, you have it in place. If you have it in place, then it grows with you. So then you get married and you create trust for your children. And if the numbers of your children grow, you add them to the trust and the will. And if they become young adults, you don't need trust anymore. And you make sure, if it's important to you, that you take care of these family members.
And you always update the will. You should always.
Yeah, you have to, because people have a tendency to do will and not look at it for 25 years. It's just natural, but you have to eyeball it because changes have to be made.
How often would you say somebody has to redo their will?
I mean, again, it really depends on the dynamics of somebody's family, but taking a look at a will every 5 years is harmless.
Yeah.
Because we're always, in fact, we updated a will yesterday for a client because she had 3 children, 3 adult children, and apparently there was a falling out with one of the adult children who was incarcerated for something very serious, and the mother was terribly upset and came to us and said, I want his name removed. I want my estate to go to my other 2 children.
Wow.
So things happen for lots of reasons.
They do.
Lots of reasons.
What are the most extreme, and you mentioned a few already, extreme cases that stick out in your head?
But those are some of the ones that I've been involved in. So, I mean, when you talk about extreme cases, there's some interesting headliner cases that go back quite a few years. So you have that I'm thinking there was a headliner case involving Howard Hughes. Howard Hughes was probably one of the first billionaires, and he died as a recluse, if you remember.
I do.
He hid himself away from the public. His hair grew down to his waist. He didn't trim his nails. They were like curly and whatnot.
And he grew a beard?
And yeah,
one smart thing he did.
He grew a beard?
Grew a beard.
Well, when Howard Hughes passed away, 22 wills were presented as his last will and testament.
What? How's that possible?
Well,
the latest conspiracy.
22 wills were presented. And the court that had the jurisdiction had to now try all of these parties who are presenting wills in order to determine which is a real will. Now, the guy's a billionaire, so it goes without saying that so many of those wills were frauds. They were forgeries. Signatures were forged because there was something to be gained. The guy was a billionaire. We didn't know what a billionaire was. He sold TWA Airlines and everything else. So the court spent over a year trying these various wills and did come to a decision and identified the last will in time that was a legitimate will. I don't necessarily remember the particulars of it, but whoever was named in the will that was accepted by the Register of Wills office and approved by the court, that's the will that was probated.
I know it wasn't mine.
And it wasn't mine.
Was it yours, Alex?
Yeah. No, I don't have one. Who should I leave my 2 crappy cars? And
and I mean that's one that stands out. The other one was always an interesting. Well, there's the other one was there was a hotel. There was a family that owned hotels, Hemsley's. They owned all these major hotels in New York. Remember? And so.
Yeah, what was her name?
So he was the brains in the family,
right.
But he died first. So Lenore Hemsley.
That's it. I think so. Yeah.
She inherited this vast fortune. Lenore Hemsley left a will, and she left the entire fortune to her cat.
I remember that.
So she left the entire fortune to her cat, and the court had a job ahead of them because that didn't make any sense to the public, but the court decided to read into it and say the woman loved animals. The woman cared for animals.
I was going to marry that cat at one time.
Well, that court decided that the various SPCAs around North America should benefit from that money, not just the one cat. And there was enough money to keep that cat in the lifestyle it grew accustomed to. That was a true story.
It was one cool cat. Yeah,
that was one cool cat. I can imagine it didn't have a rhinestone collar. It probably had De Beers diamonds around its collar.
It's amazing. I do remember that.
Yeah.
Leona Helmsley.
That's right, Leona Helmsley.
Leona, yeah.
And then the one other headliner case which was intriguing way back when. So there was a case, and I'm going to try to think of the name of the woman. It just escapes me. So there's a young married couple, and the wife sadly sustains a cerebral aneurysm.
Oh, boy.
And she is pronounced brain dead. Karen Ann Quinlan.
Oh, yeah. Oh, remember
Texas
that? Remember
case.
Karen Ann Quinlan?
I remember the Shivo one, which speaking on the medical declarations.
So Shivo is the second one. So the Karen Ann Quinlan was the first one. And so what happened in that case, and that was in Florida, where the Florida courts, and the other case was in Texas, where these courts stuck their nose where it didn't belong. So Karen Ann Quinlan's parents were born-again Christians.
Right, I remember that.
And the husband, after securing the opinions of 5 or 6 neurosurgeons who all concurred that she was brain dead and she would not regain normal function, he made a decision, the husband, to take her off of life supports. Mm-hmm. The parents ran to the Florida courts and said, wait, we want an injunction. We believe in miracles. and therefore we do not want them taken off life supports. So the lower Florida court stuck its nose where it didn't belong, and so there was an appeal to the middle courts, and it ended up with the Florida Supreme Court ruling that the parents had no say in this matter because she was married and it was the decision of the husband, not the decision of the wife, which simply emphasized why are healthcare directives so important.
Correct.
In the same breath that people are doing wills, they insist on healthcare directives. And the other case, Alex, that you mentioned really followed the same game plan, but that was in the great state of Texas, where they got to tell you what your business is. Well, even the Texas Supreme Court said, no, mother and father, that's not your decision. That's the decision of the husband.
Wow. And Karen Ann Quinlan eventually died.
Yeah, she was taken off of life supports and she passed away. And therefore, it's the start of these written legal documents where you assert control over what happens when you can no longer function normally.
If you think about it, Karen Ann Quinlan, I understand the parents. They want to keep their child.
I understand
alive.
it.
But I understand the husband because, sort of, because he, one, may not want to see his wife suffer anymore, and two, technically, and she was on life support for a long time.
She was, because of the litigation.
Because of litigation.
Yeah.
So he could not, he was still married. He couldn't get married. He couldn't meet somebody else.
That's true.
Decide to get married and so forth and go on with his life and maybe have children and so forth, because technically that would be bigamy.
That's correct. You're correct.
So that, as we're talking, just occurred to me. That was maybe part of what he's thinking.
There's no doubt. I would think no spouse wants to see a sick spouse suffer,
Right.
and unless you stand in somebody's shoes, you don't have the same appreciation. But I am sure that played a major role in the person's thinking.
Yeah.
And so once again, the underlying theme is control. If you don't have a will where you express your thoughts in writing, Pennsylvania has a statute. If you have elderly parents that have needs and their minds are failing and they don't have a power of attorney naming an adult child, that adult parent has no voice. And like the millennials and the Gen Xers, if you don't have health care directives which give your medical provider specific instructions, there are 7 specific questions that you have to answer with a check mark. Either you want this, you want heroic measures, you want this, or you don't want this. That's an extension of you controlling the treatment you're going to receive, even if you're in a state where you can't function normally anymore.
Mm.
This is what it's all about, and that's why the emphasis is on getting these documents done.
So can someone write it out for themselves?
It's a good question. I mean, you've got all of these online forms.
Right.
Susie Orman.
Susie.
I love Susie Orman. Susie Orman says to do this. Susie Orman says, do this fill in the blank form. I said, okay, what do you want me to do? I want you to look at it. I said, no, I'm not going to look at it. I can only prepare a document that's consistent with Pennsylvania law. I said, you're going to take a form, whether it's Susie Ormond or all these forms that you see online. What makes you think that form satisfies the requirements in California, Texas, Florida, Pennsylvania, New York, Vermont? It's not a pair of shoes. One size doesn't fit all. We've got specific rules and regulations. And if you don't comply with those rules and regulations, that will may not be accepted to probate. And then you got other issues. Those other issues depend on the dynamics of the families. Look, if you have a will and you have 3 children and your spouse is gone, and for whatever reason, in your will you name one child and say, that child gets 100% of my estate. That's exactly what the court's going to do. Say, that's a valid legal document, complies with Pennsylvania law. You name that child's going to get 100% of your estate. If there is no will, and the child said, but my father said, I'm getting everything, Pennsylvania statute said, oh, how many children are there? Oh, there's 4 of you. Well, guess what? All 4 of you are going to share. It goes back to the instance of an adult child who gives up part of their personal life to move in with an elderly parent and take care of them for years. And the parent says, I'm going to take care of you, I'm going to take care of you, I'm going to take care of you, and they don't get around to it. That child is treated no different than any of the other siblings in the picture. But if you do something like put the child's name on the deed, so if something happens to the parent, the child will become the owner of the property. Do a will. If you want to name all the children, that's fine. Give that child something extra if you want. Put it in the will to show your appreciation, but put it in writing, because without it being put in writing, wars break out. And here's a typical situation. Client calls me, said, Mr. Langsam, I took care of my mother for the last 10 years of her life. I gave up my job. I moved from New York. I came to Philadelphia. I was her keeper, her health aide, 7 days a week, 24 hours a day. Mother dies. She's living in the house. She gets a letter from a lawyer. The lawyer represents her 2 brothers. The lawyer says, we'd like to have this house sold because you only have a 1/3 interest. And I represent your 2 brothers, and they each have a 1/3 interest. 2/3 is going to trump 1/3. And we deal with that dilemma. And it never ends well. And so what are the options? The options are that if you are financially with it, you determine the fair market value of the property and you buy out your 2 brothers. So if you get a house that's worth $150,000, pay each brother $50,000, they sign their interest over to you, you own the house. What's the likelihood that these people are going to have that kind of money? Mm-hmm. Slim and none.
Correct.
And so ultimately what happens? The ugliness sets in. I've been down this road a couple times. There's a contest in the courts. We file a complaint asking for a court order to sell the house. The judge appoints a master who's usually an attorney. The master will hire a realtor, whoever they do business with. The property will be put on the market, and the property will be sold. And then the monies will be distributed. Now, the distribution of monies, if everybody's on the same page, there's an equal distribution of monies. In the last case I handled, which lasted 2 years in court, mother dies and leaves a very modest home in West Oak Lane, and the house was worth about $140,000.
That's a section of Philadelphia.
Yeah, it's a section of Philadelphia.
Yeah.
I actually grew up in West Oak Lane. And the house was worth $140,000, and the only survivors were 2 daughters. One daughter, the daughters were not close. They didn't even talk to each other. One daughter was kind of like on food stamps. The other daughter worked very hard. She had a job, and she came to me and said, this is the dilemma that I'm in. Can you help me? So I sent a very friendly letter to the sister, and I said, look, mother died. Her only asset is this house for $140,000. Your sister's not interested in the house. If you're interested in the house, you can become the owner. You just have to arrange to compensate your sister. That letter was ignored. So I then authored a second letter, friendly letter, and I said, look, your sister's not interested in the house. You're not interested in the house. Why don't the two of you hire a realtor, sell the house, divide the proceeds, $70,000 each, and live happily ever after? That letter was ignored. So what this woman does is she allows her eldest son to move into mother's house, and the first thing he does is he changes the locks. So now my client can't even go into the mother's house. This litigation, why was there litigation? Because the son fancied himself as a carpenter, and he started doing renovation work in the house without permits, and inflicted $40,000 of interior damage to the property. So at some point I had to file this complaint. And when the master could not get into the house because the key I had and he had was the original key that was changed by the son, Judge Wright, that was his name, W-R-I-G-H-T, flipped out. And he called an emergency hearing in his courtroom for 2:00 in the afternoon. He called it in the morning, calling the daughter, calling me and saying, you will be in my courtroom at 2:00.
This is the daughter whose son was living there?
That's correct. And so...
That's not the daughter that you originally represented.
I still represented her, but I could go in on her behalf.
Okay.
So the master notifies the judge that they couldn't get into the house. And the judge called the daughter and said, you come into my courtroom with the key. If you do not bring the key in, I'm going to have you arrested. She comes in. The judge reprimands her, takes the key, gives the key to the master. The master and the realtor go back to the house. They go into the house, and the master, the attorney, sends me about 100 pictures of the damage done to the interior of this house, which I made sure the judge saw. So now it took 2 years. Now follow this. It took 2 years to fight this fight. In 2 years, that house was tied up. In 2 years, my client was deprived of half of the rental value of that house because if everybody worked, you could rent it. So we eventually get a buyer for $100,000. It gets sold for $100,000, gets paid into court. Judge Wright now has $100,000. And he goes to both sides and say, okay, tell me how much you think you're entitled to out of this $100,000. I don't know what the other daughter said. I said, we're entitled to all of it. And I gave him one reason after another, including legal fees and litigation, all this nonsense. The judge issues an order. My lady gets $100,000. The sister gets $0.
That was it?
That was it. And I'm thinking to myself, if the woman had an ounce of common sense, she would have had $70,000 in her pocket.
Unbelievable.
And this is why the courts hate in family fighting.
Yeah.
This is why the lawyers hate in family fighting. I go out of my way to avoid those because on the heels of that case, I had 4 brothers come into me saying, there's a 5th brother who's the executor of the father's will, and they're at each other's throats. And I said, you know what? I'm not ready to go down that road again. And it's not a dollars and cents issue because we got paid everything we billed, but I just didn't want it anymore.
I get it.
Yeah.
I get it. As we're speaking, another thing occurred to me that our listeners and viewers may be thinking of but may not have. So you have a will. I have a will, you have a will, Alex has a will, everybody has a will, okay? And we move. Our will is set in Pennsylvania, and we decide to move to Montana,
Fine.
okay? That Pennsylvania will, I will assume, and I could be wrong, is no longer valid to some degree.
Incorrect.
So it's valid in Montana.
The Pennsylvania will is 100% valid in Montana. If the will document, when it's created in Pennsylvania, strictly complies with the will requirements in Pennsylvania, any other state will give that will full faith and credit.
Okay.
So you can meet at any state, and they will honor, to the letter, as long as the will does not conflict with public policy. Okay.
That's it.
There are wills, and I've seen them. I've seen wills that say, if my daughter doesn't marry a Jewish boy, she's entitled to nothing.
Wow.
Oh yeah, and that's a no-no because that's contrary to public policy.
So that will can theoretically be illegal in a state if it's contrary to public policy.
Any state, if it's contrary to their public policy.
Any state. But you still have to have changes in that will, because if it deals with property, because the property.
Well, if you accumulate, look, you can be very general, or you can be very specific. If you have 3 children and you say, my entire estate to be distributed equally to my 3 children,
right.
You're not going to quantify the value of that estate until you pass. That's when the children are going to say, okay, what did father have? Had a house, he had some stock, he had some bonds, he had some money in the bank, he had 2 cars. What's all this worth? It's worth $300,000. Each one of us will inherit $100,000.
I get it.
Yeah.
Okay.
So you don't quantify those things until later. Now, some people leave specific items to family members. Now, in Pennsylvania, you have to be mindful of the fact that there is an inheritance tax, which is 4.5%, and in many instances is not a big deal, because if you have an estate worth $100,000, you're looking at $4,500 and a little bit less. So I'm not poo-pooing the inheritance tax, but the point is that when you specifically identify assets in a will, like my insured Rembrandt goes to my son Joe, or my 1953 Ferrari goes to my son so-and-so, you begin to identify those assets. The tax collector in Harrisburg, Pennsylvania, is going to send you a love note and say, I'd like to see in the most recent appraisal for that asset. Why? Because they want to maximize the inheritance tax that the Commonwealth can charge.
Even though that painting is still a painting and hasn't been turned into cash.
That's correct. And so what I tell people, I'll give you an example. I have clients who have love affairs with jewelry. Okay. I say to them, take out a piece of yellow legal pad. Identify each piece of jewelry. You got 20 pieces of jewelry, number 1, number 2, all the way down to 20. Identify what it is. Put the name of the family member next to it. Your executor is going to know that piece of jewelry goes to that named individual. Why should I tell the tax collector that I've got 20 pieces of jewelry in this estate? In my opinion, it's none of their damn business, because a tax collector has his or her hand in my pocket and in your pocket and everybody else's pocket. So if you're dealing with assets that do not leave a paper trail, don't create one. With a home, you can't snap your fingers and make it disappear. There's deeds. With cars, there's titles.
Right.
With money in the bank, there's bank statements. With brokerage accounts, there's all kinds of stuff. You're going to have to account for that, and you're going to have to quantify that. But if there are assets that you don't have to, why do it?
That makes perfect sense to me.
I've seen way back when they used to open up safety boxes, when banks used to have safety boxes in jail, in banks, and there was a procedure. The procedure is completely different today. There was a procedure where you had to reach out to the department in the Commonwealth of Pennsylvania. There was a safety box department. They had 1 or 2 people that covered the whole state. And you had to make an appointment for that individual to meet you at the bank. You had to come with the key, and they would allow you to inventory what was in the box.
In front of them.
In front of them. And as you're inventorying it, they're writing everything down. And they would let you inventory, wouldn't let you remove anything, but would let you inventory it. And then it becomes part of the assets of the estate. Today, you don't have that department anymore. I don't think very few banks even have safe deposit boxes.
True.
They don't
True.
bother with them anymore. So you got to find someplace else. You get legitimate safes. I have one in my home, a real safe, not one of these little boxes that you buy.
Right.
And so you can't blow my safe up with dynamite. But you have valuable papers, and whatever is important, it's in there.
Yes. Now, I want to go back to the Pennsylvania-Montana thing.
Okay.
Okay? So, and why you may want to change it, because if you're
You're going to update it. You're going to update it by
that's
moving
what
to
it-
Montana. You're
You
absolutely.
got to take that house out that was in Pennsylvania and out of your will and put the house that's in Montana.
Well, you may not be naming your house specifically unless you're earmarking that particular property to a specific named beneficiary.
Okay.
But if you're using general language, my estate,
Right.
and so the term is a term of art. An estate it's like a giant umbrella over your head in a rainstorm. Everything underneath it are your assets, whether it's bricks, whether it's tangibles, whether it's intangibles, whether it's real, whether it's personal. You quantify it. You figure out what it is. You value it. Either the heirs decide to sell it and convert it into dollars and cents, share it equally, and live happily ever after.
Wow.
So if you're moving from PA, the odds are if you're moving from PA to Montana, unless you choose to rent that property, and I get that, I have that situation. I had an elderly couple that lived in Philadelphia. Their married children lived in Texas. The children insisted that mother and father move out to Texas, and that's where the parents established residency.
Right.
But they still owned the home that they were renting in Philadelphia. So when the second of the spouses passed away, they opened the estate in Texas, but they needed a Pennsylvania lawyer to handle the sale of the real estate in Pennsylvania. So they reached out to me, they hired me. We opened what's called an ancillary estate. I got a buyer, we sold the property, and we sent the money into to Texas.
Okay. But you had to pay.
You paid
Real
whatever
estate tax.
you paid
Yeah,
whatever
that's-
inheritance was the state of Pennsylvania was entitled to, only the value of that asset, not the value of the Texas assets.
Got it.
And vice versa. Texas, if they had an inheritance tax, could not include the value of the Pennsylvania property because it's not an asset in Texas.
I got it. So the main thing is have a will. And update it all the time.
Have a will.
Every
It's
5
not
years
an
at least.
expensive proposition because it gives you the opportunity to put your thoughts in writing, and it'll give you something to think about. Because most people do not put pencil to paper
Right.
and in a quiet moment try to figure out what they're worth. Because most people will be surprised that they're worth more than what they
Yeah.
think
Yeah, what
until
they
they
think.
go through that exercise.
Yes.
And everybody should do it.
I agree with you. Saul, this has been enlightening. I hope our viewers and listeners have gained insight, wisdom, and necessary knowledge for their estate planning. How do people get a hold of you if they want to get a hold
My
of you?
Philly lawyer, Saul Langsam, we're all over the place.
MyPhillyLawyer.com?
Yeah, My Philly lawyer. I always encourage people, when they reach out to me, I say, do me a favor, go onto our website. On our website, there's a tab. It says attorneys. It's got my attorneys that are working there. I said, you'll see my name. Click on the tab with my name. I want you to know who I am.
Yeah.
Because this is a lot of personal information are going to change hands. And this is not a relationship that I will build like Morgan and Morgan over the phone or through communications with a cell phone. No, if I'm going to get involved in the intricacies of your estate, you and I are going to sit across from each other in my conference room because you need to know who I am and I need to know who you are. And if that becomes a burden, I'm the wrong person for you.
Get it. Well, listen, folks. Contact my Philly lawyer, Saul Langsam.
Thank you, Dan.
And if you saw him or heard him on our show, mention that you saw him on Digging for Gold, or you listened to him on Digging for Gold. Saul, I want to thank you so much for this.
It is
enlightening.
It is my pleasure. It is my pleasure.
Thank you very much, and don't forget. So please subscribe to our YouTube channel, be a follower on Spotify, on TikTok, on Instagram. Just go to dangoldberg.com, go to the bottom of the website, click on those icons, and remember this: use your mind. If you don't, others will. We'll see you next time on Digging for Gold.